in Singapore, there's something called the Singapore Infrastructure Dispute Management Protocol, and it's about dispute boards, right? Now, there is also this thing called a conflict avoidance board. Now, I've just spoken about dispute boards, that's resolving disputes, but a conflict is before it becomes a dispute, right? So when you get a chance, please take a look at this. This is something that's set up in UK, but it's also another method of an adjudicative dispute resolution platform, all right? The next one is what is called adjudication, right? Now, this is commonly used in construction matters, right? So like in UK, in Singapore, in Malaysia, in Australia, and New Zealand, and Ireland, this is a fast-track method of dispute resolution. It's either written in your contract, provided for in your contract, or an act of parliament, which I'll show you in a minute, establishes this regime of dispute resolution, and it's a very fast-track method. So in Singapore, it first came out in 2005, right? And because of that, the number of arbitration cases have dropped. Construction arbitration cases have dropped tremendously because it goes through this process of adjudication, all right? So you can either provide for it in your contract, or it could be statutory, right? Because the laws passed by each country will provide for it. So let me give you an example of that. In Singapore, you've got the Building and Construction Industry Security of Payment Act. In Malaysia, you have the Construction Industry Payment and Adjudication Act. Again, if you click on these, it'll take you to those acts. You can read about it. In England, it's called the Housing Grant Construction Regeneration Act and Part 8 of the Local Democracy and Economic Development and Construction Act. In New Zealand, it's called the Construction Contract Act. In Australia, it's the East Coast has got one version and the West Coast has got another version, but generally they are all called the Building and Construction Industry Payment of Act in Queensland. So when you get a chance, if you find it interesting, please go take a look at it. Okay. And Justice, the Honorable Justice spoke about online dispute resolution. That too is an area that I've dealt with to some extent. And I thought maybe I'll just highlight that, right? It's basically resolving your disputes on a platform, right? Now, that platform can still have all of the mechanisms that I said, that I showed, or I just discussed with you, right? It could be mediation, it could be neutral evaluation, it could be expert determination, it could be adjudication, but it's all done on an online platform, so you don't physically have to be there. So it's exactly like me here today in Singapore. It's 8:10, 8:15 at the moment in Singapore, but I'm doing this online with you. And I hope you feel, when we get to the Q&A, I hope you feel that I am actually present there with you when we do interact with questions if you have, right? But the online dispute resolution platform allows you to resolve this. So take a look at it. The International Chamber of Commerce reported about this a long time ago. I think it was about 15, 20 years ago. And now there are platforms available where you can have your matters resolved. But you would have questions about whether or not it's binding. But that's something we can talk about in a short while. All right. Now, so that was a quick run through of ADR. And let me just, in the next 10 minutes or so, just highlight some points about arbitration. Most of this are going to be discussed by Johnson and his team extensively throughout your 50 hours. So this is just a flavor of it. Okay. So arbitration is an adjudicative dispute resolution process leading to a determination which is called award that is final and binding, where parties agree to submit their dispute to arbitration for determination by a tribunal. The tribunal can be one person or it can be 3 people. All right. You can have ad hoc arbitrations, meaning parties decide in their agreement that they want a matter resolved by arbitration, but do not say that they want to go through an institution. They just want an arbitrator to be appointed, and then the arbitrator decides on the rules and the way forward. Okay, as opposed to an institutional. So Justice Mustak had spoken a little bit about this, about institutions, and Johnson also highlighted the fact that you want to try and see whether in Kerala you could have a clearer structure with an institution that runs these dispute resolution mechanisms. Okay. Some of the things that Johnson and Justice had mentioned: party autonomy. You get to decide yourself that you want to have this matter resolved, but it is the arbitrator that decides at the end of the day. There's this issue of confidentiality. There are issues about the rules that you follow. There's this thing about, it's called a seat of arbitration. It's a private hearing. There's an award that can be enforced internationally, which Johnson had mentioned. It's part of the New York Convention. Party autonomy. At the start of the contract, parties themselves decide, I do not want to go to court, but I want my matter resolved by arbitration, and they put it in the agreement. So that's the biggest advantage, one of the biggest points about arbitration. Parties themselves decide that they want their matter resolved by arbitration. They decide whether or not it should go institution, follow a set of rules, and so on. There's laws that are applicable as a result of arbitration. Again, I think Justice had mentioned this, that there's the act in place, and you have rules that are that you can follow clearly, right? So you have a very structured method of a dispute resolution that does not require you to go to court, doesn't require you to be in the public domain, but in a private domain. All right. Now, some of the institutions that are available, I thought it was important to highlight, was the Asia International Arbitration Center, which Johnson had mentioned. The director is going to come speak to you all. The China International Economic and Trade, sorry about that. Hang on a second. I jumped again. So sorry, I'm just going to. Hang on a second. Sorry. Let me just stop this and start that again. Right? Okay, back here. What happened just now was that because I accidentally clicked on it, it went to the website to show us what it was. Okay, then you have the Korean Institute as well. You've got the London Court of International Arbitration, and you have the Singapore International Arbitration Center. So these are all institutional arbitration centers that run. So if you have a system that's clear like this, and many of you may have heard about the Singapore International Arbitration Center and the work that we do here in Singapore, but these are institutions that allow your arbitration to be administered in a proper fashion. All right. Now, in India, I mentioned right from the start, you have the Arbitration and Conciliation Act and its amendments. I'm not sure. I do apologize if I missed whether there are further amendments or not. But in Singapore, you have, for the domestic, you have an Arbitration Act, and for the international, you have an International Arbitration Act. And the international one deals with the model law, deals with the New York Convention, all of which you're going to learn about in the 50 hours that come up, right? So this is the advantage of going down the path of arbitration, because they are all acts and rules and institutional rules that are in place. All right. Again, I think Johnson mentioned this ancestral model law. You will be talking about this extensively, so just take a look at it in passing from my notes, from my lecture handout. The international regime is enforcement. It's called the New York Convention on Recognition and Enforcement of Foreign Arbitral Award. What it does is that once an award is made, if the party that's supposed to pay up doesn't pay, you can go after that party's assets wherever they are around the world. 165 countries, or 166 countries, I think, are signed on to this convention. So if there are assets in those countries, then you can go and enforce them. So that's the advantage. Now, these a couple of things, I'm going to just brush through them, because I'd like to see whether or not I can take some questions before the end of today's session. Johnson will cover this, I believe, in detail about seat of the arbitration, privacy and confidentiality. I think both Justice and Johnson mentioned in passing that you get the advantage of arbitration is it's private and confidential. Nobody gets to see what the award is at the end of the day, right? You have this award that is issued by the tribunal, whether it's a one-person tribunal or three-person tribunal, and the enforcement is exactly what I'm repeatedly mentioning, the article of the New York Convention, what it can do for enforcement. All right. With that, I go into this last part very briefly. Now that you have an idea of the appropriate dispute resolution mechanisms, and then you have an idea briefly about arbitration, I thought it's also important to just highlight arbitration clauses, right? And the reason for that is this. Uh, very many problems arise because people don't draft their arbitration clauses correctly, right? So just have to go click. You just go click here. You find in Singapore, there's an example of the appropriate clause that you should use. These are all examples of how it should be laid out. So you find that having an arbitration clause crafted in the right way is an easy exercise. So if you have parties and you're going to advise parties on entering into an agreement and you want them to deal with their matter through arbitration, examples of which arbitration clause you want to use is very easy to find. Right? The Chartered Institute of Arbitrators have got a model arbitration clause, and it says any disputes, controversies, or claims arising out of or in connection with this contract or the breach, termination, validity thereof shall be submitted to the Chartered Institute of Arbitrators and using their rules. All right. You may have heard of multi-tier clauses where it says that if you have a dispute, you start with the management. If that fails, you go into negotiations. If that fails, you go into mediation. If that fails, you then go into arbitration. So there are these kind of clauses, but it can be tiered, or it could sit at the same level. So for example, I advised the Singapore Institute of Architects about 10 years back on dispute resolution clause, their agreement, their contracts. And in there we have expert determination, mediation, and arbitration all sitting in the same platform. Parties just decide which one they want to do or go under. They don't have to start off with one and then lead to the other. All right. So this part, you can take a look at it on your own time. Right. What is most important is that you've got to be very careful how you craft it, and the wordings must be accurate. So once you get that right, you should be on your way. All right. With that, just a couple of one or two concluding comments. This is something, I think it was one of the first speaker, I think, who mentioned about COVID and how we are all in the same place at the moment, exactly in the same place. And I thought this quote from something in 2020, when the pandemic just blew up, was so very important, right? It says that the fault lines of today's world, most notably social divides, lack of fairness, absence of cooperation, failure of global governance and leadership, and the critical degradation of our natural assets, lie exposed as never before. And many now feel the time is for reinvention may have dawned. The concurrence and severity of these fault lines mean that we are now at a critical juncture. The potential for change is unlimited and bound only by our imaginations, for better or for worse. He went on to, these gentlemen then went on to say that societies could be poised to become either more equitable or the opposite, geared towards more solidarity or greater individualism, favoring the interest of a few or looking at the needs of the many. Economies, when they recover, could be characterized by a greater inclusivity and more attuned to our global commons. So it's about all of us being the same platform and all of us wanting to work together to have their matters resolved. Will there be enough collective will to take advantage of this unprecedented opportunity to reimagine our world in a bid to make it a better and more resilient place? At the end of the day, keeping aside the other crises. And that's it. What this tells you is this: we need to relook how we look at the world and how we look at disputes. We need to understand that it's no longer just about going to court. If there are avenues and methods of dispute resolution that is to me, far more effective and somewhat superior to just going to court, right? And we have this advantage and this point in time where the world has come together as one, right? And we want to look at how we can try and resolve our disputes in a far better way. And this initiative that Johnson has taken to teach and train you all in, not teach, but to share with you on arbitration is a perfect example. And I thought I'd leave you with this. Abraham Lincoln had said, discourage litigation, persuade your neighbors to compromise whenever you can. As peacemakers, the lawyer has a superior opportunity of being a good man. There will still be business enough, right? And Buddha said this, do not dwell in the past, do not dream of the future, concentrate your mind on the present moment, right? And the middle ones are some things that I had done. In 2019, I had published a book, and just out of the pandemic, I had said a couple of things. The hyperlinks will take you to that. In my role in Mediators Beyond Borders, I had an article in last April, where I said all roads lead to peace building at the end of the day. So I leave you with that. While I'm a litigator and a practitioner that goes to court, I very often end up with trying to make people appreciate that we can solve our problems far better method than just going to court. All right. So thank you so much. I will share my presentation with Johnson. I'll just have a couple of points to add to it, I think, and then I'll send it out to him. And once you receive it, you'll note that the PDF version of that will hyperlink and take you to all of the key points that I've mentioned.